Hi everybody, this is Arcadey Frekhtman. I'm a New York City personal injury trial attorney, and this particular video is going to be all about how a trial lawyer can pick a fair jury. And so I did part one while I was away in Huntington Beach, California for a trial lawyers university, continuing legal education, where I learned a lot. I did a lot of workshops with some of the top trial lawyers in the nation. And I also even talked and lectured in a series called Turning Points of Trial, where I was the instructor and I talked about my case where we settled a slip and fall on ice case for $3.5 million. And then when I came back to New York, I was actually back on trial. I had to go to the Bronx Supreme Court and start a trial yesterday. And we started and we were about to get going, but then the case ended up settling. And I'll do a video about that. It's an interesting case, very different, almost like a very unusual kind of accident and a serious injury. And we got a really good settlement, a multi-million-dollar result. So I'll talk about that as well. And maybe we'll have Richard back on because we did the case together. So we could talk about that case and do an entire series about that. But this was the video I did about Jerry Spence. And this is an article from Jerry Spence. It's actually also a continuing legal education. It's called Creating the First Impression Voir dire, or voir dire, I don't know however you pronounce it. Jury selection, picking a jury. You want to pick a fair jury because if you pick the right jury, then those are the people that are going to decide the case, right? They're going to answer questions. Was the defendant negligent? Did the defendant's negligence cause the injury? And then what is fair and full compensation for the injury? That's all decided by the jury. So if you pick the right jury, then you get the right decision. So let me continue where I left off. In part one, I talked about a few things, and you could watch that video. But I think we finished up talking about jurors' rights, and he almost like empowers the panelists because they're not jurors yet, right? What happens is you get a panel to talk to, let's say a panel of 20 people. And as you're talking to those prospective jurors, those panelists, you could then, explain things to them. So the way he likes to do it is he tells them, you are citizens too. You have rights. And you have two important rights. And number one, you don't have to sit on every case, right? Because you might have certain beliefs, certain feelings, the way you view something, and that's fine. And for example, you might not like a certain type of case. For example, you might be sensitive to criminal activity. So you wouldn't be the right juror for a criminal trial. Somebody else might think that there are too many frivolous lawsuits. So if somebody says, oh, my neck hurts, I was hit in the rear by a car crash, that person might think, well, I think there are too many lawsuits already, and I could not be fair toward somebody bringing a lawsuit saying that they have neck pain from a car crash. Maybe because I was in a car crash, right? And it was a little fender bender. I didn't have any pain, so I don't believe you. And right away, I can't be that fair and that neutral juror that can give both sides a fair shake, right? Because there's the plaintiff who's suing and there's the defendant. So if you can't give both sides a fair shake, then you're not a proper juror. And sometimes people just have certain inclinations or certain feelings, certain viewpoints. And that may say, like, for example, hey, I wouldn't be a good juror for a criminal case, or I wouldn't be a good juror for a car crash case. So you have to really speak to them, and they don't have to sit on every case, right? Because there's so many different kinds of cases. There are trip and falls, there's construction accidents, there are Uber crashes, there are burn injuries, electrocution injuries, there are medical malpractice cases, and all those are just personal injury cases. What about contract disputes or cases, business partnership disputes, right? Or some kind of commercial law. And there's family law, custody of the children, divorce, so many immigration. There's so many different types of cases. So you don't have to sit on every case. And the other thing that he points out is that as a juror, you do not have to agree to every proposition of law that the judge gives you, because the judge is going to say, hey, this is the law. But maybe you don't like the law. Maybe you don't want to follow the law, right? Like, you don't really have to do much. Like, for example, you have the right to vote, but you don't have to vote. There's going to be an election. Maybe it'll be Trump against Biden, right? You don't have to vote. You can stay home and say, forget it. I don't want to vote. The only thing you really have to do is, I guess, you have to pay your taxes. You do have to go to jury duty, but going to jury duty just means you show up and you give them a chance to chat with you. It doesn't mean that you have to serve as a juror on a case that you have strong views about or can't be fair on, and it doesn't mean that you have to agree with these propositions of law that the judge gives you. And he gives an example. He says, for example, you can't be sworn to follow the judge's instructions. For example, if he says, go and bomb City Hall, for example. And, that's something that's a crazy example. But, I mean, there are many examples where you may not agree with the law. So then he says that we are all individuals, and each of us has our own idea about what is right and about what is wrong. And we are preachers of our experience and of what has happened to us. And so it does not follow that we can't all see things the same way, and that we might not all agree that the law that is involved in this case, right? There might be a certain type of law in this case that you don't agree to, and that's fine. So he's explaining that the voir dire, the jury selection process, is as much for the prospective jurors, the people who get the summonses, as it is for anybody else. And then he basically says, well, how many of you would be willing to stand up for your rights? You see what he's doing there? He's empowering the jury. That's important, because you want to empower the jury. You don't want the jury to be afraid, because, ultimately, if you're a plaintiff's attorney and you're suing, you want the jury to be comfortable. You want the jury to be empowered. For example, if you're suing for $10 million, if the jurors are afraid and they're like, well, I'm just a little juror, the judge decides everything, I'm so scared, there's no way they're going to give you $10 million, right? You have to be pretty empowered, pretty relaxed, pretty chill, pretty in control to put down something like $10 million on a verdict for him. So that's what he's doing. So he talks about standing up for their rights. And he said that he has now conditioned the jury's idea that they are not going to make me sit on this jury. And that's true, right? They don't make you sit. It's something you have to choose to do. And it's really a choice that you make together, the attorney and the prospective jurors. And then he says, let me ask you this question. Isn't the true function of voir dire to somehow educate the jury? Isn't jury education important? We want them to know all of the propositions that they have to think about. Don't we want to lay it on the table? And that's true. You want to lay it on the table. You want to explain everything. And he says that the jury is the most beautiful tool of justice that was ever devised by man. And he talks about the fact that to be successful with juries, you have to tell the truth and you have to be straight with them. And if you have any problems in your case, you want those problems out in the open. You want to front them, discuss them right up front. So he asks the other lawyers, this is a CLE, right? He's teaching, this is Juror Spence teaching other lawyers. So he asks them, he says, what are you afraid of? That is the great question to ask yourself in the presentation of your case, and then go to the jury with it. And he goes, I'll show you how in just a minute. And he says, the way to do it is with the open-ended question. For example, and this is Jerry Spence now talking, he says, this is a case in which I have asked for a lot of money. I mean, a lot of lawyers don't like to talk about money. They are scared to talk about money back up to you like this. And then at the last minute, they ask for a lot of money. Yeah, that's true. Like, a lot of lawyers will not mention money at all. They don't mention it in voir dire. They don't mention it in opening statement. They don't mention it in the direct examination of any witnesses. And then at the end of the case, they just pop it like towards the end of closing argument. They just say, oh, by the way, we're going to ask you for $7 million. And the juror's like, what? Well, where did that come from? And it's just like, it's not going to happen. So the best way to do it is to tell them right in jury selection, hey, this is a case where we believe the evidence and the law justify a verdict of $7 million, and say it confidently. Or another way to do it is to say, when you match up the evidence with the law, a jury verdict of $7 million will be justified. You got to say it confidently and believe in it. So you tell them right in jury selection. And would you have any issue sitting on a jury when you know that that is what we're going to be discussing in this case? A case worth $7 million. And some people might say, no, I don't want to be on the jury. Some people will say, yes, I'm open to the possibility. So you pick your jury. Then in opening statement, you could tell them again that the evidence will show that this case is worth $7 million. Then when you say it in closing argument, now they've heard it. They've heard it all the way through. It's not a problem, and they're going to give it to you. So he's completely right. But here he's talking about the open-ended question. So what he says is, I didn't want to tell you up front that this case was worth a lot of money. And he says, I am asking for $10 million for my client. How many of you are? I mean, that is a lot of money, isn't it? $10 million for a human life. It is for little Mary. She was run over. And I'm afraid that she'll say that we shouldn't give money for a dead little girl, or that Mrs. Jones ought to be ashamed coming to a jury and asking for money for her dead baby. So this was a case where, Mrs. Jones was the mother and her daughter was run over. So see, he brings up all the problems. He brings up all the thoughts that a juror might have right up front. And I'm afraid that you're going to say that no one should profit from the death of their child. And that is what I am scared of. Now let's talk about it, Mr. Brown. What do you think about giving money for a dead baby? And he what do you think? Tell me more. And then he just lets the jurors talk. And he just continues. He says, what do you say, Mr. Smith, about getting money for a dead baby? It seems like a lot of money. It is a lot of money. Thank you. And how many of you agree with Mr. Smith that it is a lot of money? What did you think about the idea of giving money to a mother for the loss of her baby? Does that bother you? Does it bother anyone here on the jury? I think you're crazy. I can see that. I have been looking at you. You know what? When I told my wife that I was asking for $10 million, do you know what she said? She said, I think you're crazy. So you see, he's not arguing with the jurors that think he's crazy. He's embracing them, right? He's saying, yeah, that's true. So he's basically, and that gives him more power, right? More vulnerability, more authenticity. And then he says, let me ask you, Mr. Young, do I have your permission to try to show you that this would be a just verdict in this case? And the juror says, you can try. Would you permit me to try and do that? I don't have any other choice. All right. Would you rather not sit on the jury? No, I would like to hear it. You would like to see whether or not I could show you that? Yes. Would you leave open in your mind the possibility that a human life could be worth 10 million? Are there in your minds some human beings that would be worth 10 million? And the juror says, none that I could think of at the present time. There aren't any that you can think of, right? Well, I see that sort of the same way. Between you and me, Mr. Young, if I had the choice between the 10 million, I guess I would take my life. I think that my wife would make the same decision. And I think that my father and mother would make the same decision. But can you leave room in your mind, Mr. Young, that there are human beings in this world whose death ought to be justly compensated with a sum as large as 10 million? And then he talks about some examples like President Reagan. I guess this is an older CLE, so he's talking about like President Reagan. And he's saying but the point is that, the jurors are doing you a huge favor by being honest with you. And if they're honest in a negative way, that's a great thing, right? Because now you know these are not your jurors and they're helping you by telling you that, and you're able to then remove them from the jury for what's known as cause. So that's a gift. So yeah, he gives some other examples. He says, can you open your mind up to the idea? I don't want to ask you for a commitment or promise because I don't think that is fair. But would you be open to me trying to show, in this case, on behalf of Mrs. Jones, the mother, that little Mary's life is as valuable as President Reagan's life? Would you let me do that? Do I have your permission? And would you leave room for the possibility that I could do that? You are not close to that, are you, Mr. Jones? Well, thank you. I think he means you are not closed to that. Because if you're closed to something, well, then you can't no matter what you do, right? You could be the best lawyer, you could have the most evidence. If they're closed to the possibility, well, then you've lost right away, right? And then he says that I am able to begin to educate the rest of the jury about the value of human life. And he says the way to talk to the jury is just common, ordinary English, as one human being to another. And another lawyer, actually a lawyer at this California CLE that I was just that I just returned from, said, talk to them like you talk to somebody at the kitchen counter, just like, or you talk to somebody in a bar, just talk to them, nice and, you don't want to use any kind of legalese. How many of you are intimidated by $10 million? I mean, scared. I thank you for saying it scares me too. I mean, it's just like, here's a checkbook on the table and here's the amount, the place to fill in the amount, and it says $10 million and there's the signature, and it'd be pretty scary to sign it, wouldn't it? Do you think you could, if you believed it was just and fair? Mrs. Andrew, juror provides name to him. If you thought it was just and fair, could you overcome that fear? Sure, if I thought it was the right thing to do, but it would scare you. I told you a little earlier that the thing that worries me, do you notice how I am up close to this jury now, and I am talking very softly to this jury, because juries don't like to have people yell in their faces any more than you like to have a dinner companion yell in your face. And then he says, what I am really worried about, Mrs. Andrews, is that back in the jury room, when it comes time to do justice, somebody will say, I can't give money for a dead baby. Can you make room for the proposition that that's exactly what Mrs. Jones said to me when she came in? I can't ask for money for my dead baby. Can you make room for that? Do you realize how frustrated she must be when she understands that that is the only thing that our system can give her is money? Do you understand how it might be to be a mother who says, I'd rather have you give me anything. Give me 5 minutes of her life back. And they can have all the money. If you could do that, we'd ask you to do that. Do you understand that, Mrs. Andrews? And the juror says, I sure do. So yeah, he's making a good point that that's the only remedy the law can give you, right? The law can't give you a dead person back. The law is not going to punish somebody with an eye for an eye. The only remedy is civil justice, is monetary justice. And then he talks about, what is it that any of you are most afraid of in your jury? And he's asking the lawyers that are listening to him. What do you think about giving a woman like this justice? Do you think that would be all right? Would you give her as much justice as you would a society dame? I want to ask you that. How many of you would give her the same amount of justice as you would a society figure? How about it? Would you? And he says, would you make room for the possibility that she is entitled to the same justice as Nancy Reagan in this country? And then he says at the end, now I guess I want to say one more thing. Do you understand that this mother only brings suit as the guardian of her baby, and that the money recovered in this case would be subject to the direction and supervision of the court, and that she isn't going to be able to go out and spend it wherever she wants? It is for the child. It is for the baby. She brings it for the baby, and so the suit really isn't for the woman, but it's for a little baby who will never walk and never talk and who will never play like other children. I guess now he's talking about another case where a baby is severely injured, like a medical malpractice case. And can you understand that? Is that all right with you? Will you give that little child the same justice as you would the child of the president's wife? And that's the ending of his CLE. So I'm going to see if it's actually available so we could maybe watch a video of it. I don't know if this was ever videoed. This is a transcript of it, but I thought it was a really interesting CLE, and there's a lot of gold nuggets in there that you could use for your CLE. So I'm always learning. I'm always trying to improve, and I think this is a great way to do it. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. If you need a consultation or have a question, just text me, 347-566-9595. I'm happy to jump on a call and provide a free confidential consultation. And if you just have a comment, feel free to leave it. We do our Last Week Tonight series where we read comments for the week and then make a video answering your comments, as well as our series where we go live and we answer your questions live, which we're going to start doing again soon. Okay, everyone, talk to you very soon. Have a great day. Bye-bye.